essentially for today, my aim would be to ensure that you go away with the mind that I'm not instigating litigation from the suppliers. I just want you to understand what is there, what is available for you. And in the same way, I also want procurers to go away with more understanding about tips they can put in place to ensure that their procurement practices are more compliant and, as a result, minimize the risk of legal challenge. So that's the caveat I'm putting on this presentation. It's not meant to instigate legal actions, but it's to put everybody on an equal footing ground so that we are all living in a happier procurement environment. So the outline for today, I'll be looking at the remedies regime. I'll introduce you to its purpose, as well as outline the legal framework on this, both within the EU and the UK. Then we'll move on to the enforcement of the public procurement rules at the EU level, and also look at what you can do, the options available for you within the national system, basically within the UK. Importantly, I'll then be giving you some practical tips as suppliers on what you can do to ensure that the obligations that have been set for supply and procurers to enable you participate more favorable in this market are actually made available to you. And then the principles that need to be observed by contracting authorities. This would hopefully forestall more litigation, or perhaps make it a more balanced perspective. So what is the remedies regime? Essentially, it's a big word that everybody keeps dropping around: remedies, remedies, remedies. And I've indicated here that remedies regime involves legal actions which allow economic operators to request the enforcement of public procurement provisions and their rights under those provisions. When we talk about public procurement provisions, we go back to Pedro's presentation where he's talked about both the EU principles as well as the procedural rules that are entrenched within the directives. So we will be, the essence is to think about it that it's not just about the principles that are in the directives, because some of you here may not be interested in contracts that are covered by the directives, that is the contracts above £173,000, but may more likely, as small suppliers, be interested in contracts that are below that threshold. So we're looking at the regime that's available for you to look at where there are either intentional or unintentional failures to comply with public procurement rules. Although a caveat needs to be put here that the public procurement regulations, yes, they apply to above threshold contracts, but as we would see in subsequent contracts, there are still options for you if you're not happy with below threshold contracts. So don't think because you're not participating in high level contracts, there are no opportunities for you to actually ask for a legal review of a breach of the procurement principles. Essentially, I've indicated that some of the purposes of the regime was to actually ensure that there's greater compliance with the public procurement principles. Going back to the introductory lecture we had from Pedro, we understand that the aim of the EU is to build a single internal market so that irrespective of your nationality as an EU business, whether you come from, you're based or registered in England or Wales, or whether you're based or you're registered in Germany, you do have equal opportunity in accessing contract opportunities in different member states. So the EU principles there and the remedies regime ensure that there is that transparency of equal opportunity for you. I also ensure that there's a building of confidence in public procurement process among businesses. Obviously, where rights and obligations are given, if you give it back the opportunity to challenge the actual performance of those rights and obligations, then there's likely to be more adherence to such principles. Fundamentally, a third issue is the fact that the regimes aim to facilitate competition. Obviously, if a company in UK is aware of the fact that it can actually ask for a legal review of an action in a contract process it has taken part in, for example, in Ireland, where Emma would be talking about, then there is that possibility for more competition amongst EU, among English or Welsh businesses and Irish businesses, because as we know, the market is expanding. People are always looking for opportunities outside their base. Fundamentally, the regime aims to ensure that as procurers amongst us, we actually follow the right procedures. So for procurers that probably have been challenged before, they would ensure that the next time round, they actually adopt more appropriate procedures to minimize the risk of legal challenge. And finally, it is a very useful mechanism for monitoring contract award procedures. One of the things that Pedro mentioned in his slide was the fact that we have a number of different procedures. When we come to some of the slides, which I will demonstrate with you, will see that a lot of the issues that have come before the court have been as to whether a particular procedure was adopted in a manner that complies with the EU rules. And the regime would ensure that where there has been a previous breach by a contracting authority, in future the authority actually ensures that it complies with the requirements of those procedures. Here on this slide, we've got the legal framework. Essentially, going back to Pedro's slides, we come away from, I think one mistake people make when we talk about the Remedies Directive, they end up thinking about just this one, Directive 2007/66. But before that, there has been directives, existing directives, and they continue to exist. So it's not just about the 2007 directive. We have to cast our mind back to both the 1989 and the 1992 directive, because what the 2007 directive does is not to abolish those directives. It simply amends and develops the principles that were already formulated in those earlier directives. And Directive 89/665 relates to the public sector, while 92/18 relates to the utility sector. So always bear in mind that it's a holistic bundle of documentation. It doesn't start from here. There is a preamble from 1989, and that progress has been existing. Within the UK, we see that these are all implemented in some way starting from 2009. And the UK regulations took effect from 20th of December 2009. Last year, in August precisely, it was slightly amended, and the amended version of it takes effect from 1st October 2001. Why are all these dates important? They are important because when you enter into a litigation process, you have to know which law applies to the particular contracts in question. So as procurers, for example, if a process was initiated pre-20th December 2009, the applicable regulation at that point in time would be the one before the amended regulations of 2009. So it's always very important to bear that in mind, because sometimes what we find out in the cases that we look at is that procurers want a regime to apply to them, or suppliers want a regime to apply to them, when the contract involved had not been commenced with that regime in mind. It's important to bear the different dates in mind to ensure that you get the best benefits of the applicable legal framework that's relevant to your contract opportunity. overview of the framework. I'm not going to go into the details of the legal framework because I think it would just bore you, and bearing in mind that we'll all be going for a tea break, it's more important to get you to entrench the principles and take away something useful for practical business. So the framework targets areas where bidders had in the past been frustrated. And one of the main areas is as regards lack of advertisement. We know, for those of us who are suppliers and who are interested in contract opportunities, we know that the basic serious breach that used to occur in the past, or that still occurs even till now, is lack of advertisement. So sometimes, I remember when I was working in one of the departments that I worked in before here, we were looking for creative ways of how to make the contract below threshold so we wouldn't advertise it. And these are things that you need to be aware of. Those are areas. Has there been no advertisement? And if there's no advertisement and there's been an illegal direct award, it is potentially an area where there can be a breach. So you need, as a supplier, to be aware. Keep your ears open. What are the contracting opportunities that your organizations may be interested in and that you hear are going on there, which have not been made visible to you? I'm not encouraging you to challenge, but I'm encouraging you to be aware. Another important thing was that the framework aims to actually increase the range and gravity of remedies available. Before, a number of remedies were available, but potentially it just normally stopped as damages. And sometimes we know that damages does not satisfy us. So now, beyond damages, we have penalties as well as what we will look at in the afternoon called declaration of ineffectiveness, which is really a very draconian remedy that has been introduced by virtue of this new remedies framework. And it's hard for me to actually say that, but it's an attempt. What happens is that the framework attempts to actually lower the hurdles that had been faced by frustrated bidders. But whether in reality that occurs, we would see from Dermot's presentation in the afternoon, because when the remedies regime was coming out, everybody was so happy that it's going to make a whole load of changes. But what is emerging from the courts speaks a different story. And in some instances, there have been arguments whether the courts are taking a pro-authority or pro-contracting authority focus in their judgments. So it's important that you use this basis to assess whether you should go to court or not. Now we'll look briefly at the enforcement, both at the supranational level. When I talk about it, it's supranational. I'm talking about if you were in, I'm talking about enforcement that's done by the European Commission on your behalf, and then the national system, what occurs within the UK. At the supranational level, there are basically fundamentally two differentiations. There's infringement proceedings by the Commission. Now, what happens here is that you have the opportunity, especially if the contract is above threshold contract, if you think something funny is going on somewhere, to actually go onto the Commission's website and actually lodge a complaint. And what happens is that when that complaint is lodged, the Commission would then take up the infringement proceeding. And normally, you are not actually even a party to it. What the Commission will do is to actually investigate what is happening. It would then issue a reasoned statement to the member state. It might not even be something that's occurring in your own member state. It might be a practice that you've noticed that is occurring in another member state that is potentially affecting your ability as a supplier to actually access the opportunities in that member state. Is it worth your time? It's only you that can tell. So there's that opportunity of infringement proceedings where you actually go onto the Commission website and then lodge a complaint, and if the Commission thinks upon its investigation that it's worth its while, it can then begin infringement proceedings. From the infringement proceedings, what happens often is that the Commission may then take up enforcement proceedings. It would not take up the enforcement proceedings against a particular authority, but it would be against the member state. It would write to the representative body of the member state. For the UK now, we used to have the Office of Government Commerce. That's now represented by the Cabinet Office. And it would ask them to comply. If it doesn't comply, it may then institute an action at the Court of Justice against the UK. So a number of these actions that you see reported in the EU reports are actually complaints made by people, but it's worth your while to actually see, is it an investigation that's worth the time of the Commission? Because there's no point reporting something if you think that the Commission would not even look at it. And the different procedures, there's a procedure under Article 258 and another procedure under Article 260, but I won't go into any of them at this time. But this is just to remind you of the fact that as citizens of the EU, you have a responsibility. Even this need not be done by a supplier only. If you are a procurer and you think there is a practice in your organization which doesn't comply with EU principles and which, as a protector or a guardian of EU rules, you think needs to be redressed, you can actually initiate it. The most important thing is getting onto the website, reporting it, and then it being taken up by the Commission. Outside that, it's beyond your hands, whatever happens there. An example of a supranational infringement proceeding that actually changed the course of EU law in this area was the Commission and Germany case. Basically, it started from about 2001. What happened there was that there used to be a 30 years service contract awarded without notice. It had been awarded all the time. That Germany, when you look at the cases, Germany appears to be, I've been doing some research on where a lot of infringement proceedings come from, where a lot of challenges come from. And interestingly, Germany keeps coming out on top. So this had been going on for such a long time. It's not stated in the report who made the initial complaint, but someone somewhere did it. And two of those the contracts were challenged in 2001. The Commission then asked Germany to change its procedure of awarding the direct contract without notice. Germany refused. So subsequently in 2004, it then took the Commission then took Germany to court and argued that the contract should be terminated. But Germany initially refused. Subsequently, it agreed to terminate one of the direct awards. And basically, the Commission then argued that for failure to terminate the second award, what should be done, it should be a daily payment of a penalty until the contract was finally terminated. This continued until finally the European Court of Justice then gave a decision that was to change a lot of things that we have occurring in the procurement regime. It was in that case that the Commission and the Court of Justice first established a principle, which is now entrenched in the Remedies Directive. And the principle is that a breach of EU public procurement rules can lead to a duty to terminate the public contract in question. Prior to this time, in most areas, it used to be the case that a breach of EU principles would lead to the award of damages. So a lot of member states or a lot of procuring authorities just took the chance and said, we'll do it. If damages is awarded, we still have our contract ongoing. We will pay the damage. After all, some people may even take the position it's not from our pocket. It's from the national purse. So there wasn't really like any incentive there. But by the time this principle was enunciated in the case, things started to change. Down the line, the principle then evolved into that concluded contracts in specific instances can become ineffective. And we know that if you award a contract and it becomes ineffective, there are all sorts of liabilities. The winning contractor can actually sue you and say, you awarded a contract to me, but I've not been able to carry out the contract. I've put certain mechanisms in place. What am I to do? I mean, there's a topical case that's going on, Alstom and the Eurostar case where people are saying where Siemens has been prevented from performing its contract because of litigation between Alstom and Eurostar. All sorts of implications could arise. So basically, what happens is that this case established a number of principles which then evolved into public procurement law, and it's now entrenched in the Remedies Directive. That concluded contracts, what we mean by concluded contracts, mean that the mere signing of a contract does not preclude the court from cancelling that contract. So before, what we used to have used to be a race to signature. Procuring authorities would feel, okay, Mr. B is complaining against this contract process. Well, we'll keep him there. We'll keep having meetings with him. As long as we proceed to sign the contract, it doesn't matter. Once we sign the contract, then what happens is that we will then address his complaints. But that's no longer the case. There is the possibility of having that signed contract cancelled or declaring that signed contract to be ineffective. So it's kind of like puts more responsibility back on procuring entities to actually obey the principles that Pedro had enunciated earlier in his presentation. The aim of this in totality is to actually lead to more efficient enforcement and increased compliance with the EU public procurement framework. So what do we see as the main effects of the directive? Like I said, the directive amended and developed the remedies regime that existed before 2007. But beyond that, it actually entrenched some new provisions. Essentially, one of the things that it entrenched was the standstill provisions. Standstill provision was actually first initiated through case law. In one of the cases that went before the EU, the court decided that in order to prevent the race to signature, there should be some time frame between when a procuring entity notifies people about its intention to award a contract and the actual date on which the contract is signed, so that opportunities will be given to the aggrieved bidders to actually challenge that decision. A lot of that was developed in case law, but in 2007, the directive took the opportunity for the first time of entrenching it in a legal framework. Then the directive also indicated that member states should provide reasonable time limits within which aggrieved bidders can seek for review of any procurement decision. Essentially, it then introduced the principle of automatic suspension, whereby the scale was waived now that rather than waiting for the aggrieved bidder to actually go to court first, if the aggrieved bidder actually serves you a notice of intention to go to court, then that, or serves you a claim form, then that actually should suspend your ability to sign the contract. And then we then go on to the new remedy of ineffectiveness, which had been present in some member states, but in member states with common law traditions, such as UK, one of the principles was that the Crown, you cannot have an action to compel the Crown to do certain things. And the Crown also referred to entities that emanate from the Crown, such as public authorities. So as a result, the court had no power prior to this directive to actually command contracting authorities to cancel a contract. Of course, then we had the damages principles, which was further re-entrenched into the directives. And now what we also have is that you can actually, in some instances, have alternative penalties imposed. So it went on to actually try to set up a more dramatic remedial system or provision so that procurers would be compelled to actually obey public procurement rules in a way that would be more favorable to suppliers. We go on to the UK system. Efforts have been done at the EU level. At national level, things have changed. Down the line years ago, we never used to talk about procurement regulations. That's why some people may say, why are we having all these detailed rules today? Because for people that may be twice my age or so, they may not actually understand where all these rules and regulations came about. So the first procurement regulations in the UK was adopted in 1991. It wasn't as detailed as what we have today, and it certainly wasn't as complex. Move on to 2006, we had the latest version of regulations. At the beginning, interestingly, the UK, as an entity, including Scotland, had one legal framework. But from 2006, Scotland felt, well, we want to do things our own way, and then decided to have its own separate regime of regulations. The interesting thing is that the regulations are very similar. So as a legal business, if you're interested in accessing contract opportunities at that part of the world, you don't necessarily have to know the delicate intricacies of each regime, but it would be important if your legal departments could actually be aware of developments that are happening there, because in some instances you might think that the same regime applies to you if you're based in Wales, whereby there might be some very slight and minor changes. So it's important to have these issues up to date so that you are aware when you of obligations owed to you, whether from over there or from within England, Wales, or Northern Ireland. And I've mentioned that basically what they do is they are similar. And going back to what Pedro said earlier, one unique thing about the implementation process was that although some provisions were optional, the UK, including Scotland, actually opted to implement all the EU rules. Some member states felt there's no point. They did a mix and pick choice, but we went the whole hog. Source of bidders' remedies. Essentially, one thing to remember in mind is that, yes, we've got this framework of rules which Pedro tabulated for us in his earlier presentation. And it's important to bear in mind that while the public contracts regulations apply to duties owed to bidders as economic operators, it applies to certain threshold contracts. So you might have a claim which may not arise from the public contracts regulations. So that may not be the source of your remedy. The source of your remedy may be based on what we call judicial review of a public law action. It's important to understand what is it, what contract are you interested into, what contract are you interested in, where did the breach occur, and what is the source of the remedy you're seeking, because that would then determine which approach to adopt. I think this is a point that most people miss. Most people think that because there is a general remedies regulation, it applies to all contracts. But there are certain things that to action you have to go through judicial review rather than through the procurement contracts regulations. And Another thing to remember is that the breach of duty that is actionable is that duty which is owed to an economic operator who has suffered, risk suffering, loss or damages. So you have to put yourself into that position. Am I an economic operator that has suffered, or do I risk suffering? This is just to prevent anybody from off the street walking up and challenging the directives. We've got one case of judicial review. I mean, in that kind of situation, it might be more appropriate to go through a judicial review process, because then you're asking for a review of a public law matter rather than in your right as an economic operator. So you need to know, where do you stand in the scheme of litigation? And we'll look at standing shortly in order to know, do I go through the public remedies regulations, or do I go through the judicial review action?
So but just in simple terms, just explain, what's the difference?
The difference is that for below threshold contracts, for example, it might be best to ask for a judicial review of the authority's action.
So that is, was the decision taken in accordance with the procedures that should have been followed?
Followed, yes. And or if, for example, you are a bystander, you were not an economic operator in the contract. For example, Mrs. Chandler, in a case that involved a school in London that had taken on a particular procurement process, she was interested in understanding whether the local authority had actually done the right thing. She was never a public authority in the contract process, so she could not file an action under the remedies regulation. The only way she could file an action was under the judicial review process. So as a bidder, you need to understand, where do you stand in the scheme of things before you commence an action.
So this is an important point to understand, is that judicial review means you're asking the court where the procedures followed, but with the public contracts regulations action, that's under the Remedies Directive, you're asking the court, was there a breach of a statutory duty? Isn't this it?
Yeah. And this one, basically, this is a general one that anybody can use. But here, you have to understand that you have to be an economic operator who had suffered or risk suffering loss.
Now, stop there, because that's another vital point, because you've got to be able to show damage or risk of
suffering damage or loss.
But here, with judicial review, you won't be having to show that. You're just asking the court, overturn the decision that was made, let's say to reward the contractor X, because the procedures were not followed.
Yeah. Or because it did not exercise a statutory duty in an appropriate manner.
Yeah. Now, the reason why I'm just dragging out those points that Emma's making there is because there's a popular misunderstanding of what is the difference between the two, and I think you've explained them clearly there.
Okay. Okay. So we this is just basically to recapitulate what the main points in the 2009 remedies regulations, and essentially it just reflects what was in the directive. Like I said, what we've done, the approach we've taken in the UK, it's almost like a whole piecemeal approach to adopting what is in the directives, but in national legislation. And essentially to note that if, for example, your procurement process, I mean, it's unlikely that in 2012 you will be suing for a procurement process that was commenced in 2009. But this slide is actually to make you understand the fact that there are enhanced award notification requirements, and that applies more to the suppliers, to the procuring authorities here more than suppliers. So you have to know which forms to use, what kind of notification you need to give because of the dates, the applicable dates. Also the standstill requirements, you have to comply with what is in the 2009 legislation.
So that means you can't rush to sign the contract, you've got to wait until that period is expired.
Yeah.
There's been no challenge.
Yeah.
Yeah.
I think it's most likely that no contracting authority would offend this principle, but just to be careful. Also note the effect of interim suspension of contracts, which is what Dermot has just said there. The fact that your decision can actually be set aside, that your award decision that had been made can actually be set aside. So this is very important, especially for a winning supplier, in the sense that some of us may have to actually put in place mechanisms in order to perform a contract. If you've won it, you might want to put in a management team, you might want to go and get a loan, you might want to buy new equipment. So it's important to actually wait out and see that what's happening before you actually put those mechanisms in place. Because what if you actually put those mechanisms in place and the contract is actually set aside? You bear the consequences. Even if you were to do that, you need to find a way of protecting yourself legally. It could be by talking to your solicitors about the kind of documentation that they need to prepare. For example, with your bankers or with your funders or with your management team. Assuming you were going to engage new employees or in an employment contract, and a contract is set aside, and you're a winning supplier, serious implications for you, So you need to be very careful. So one thing to remember is that it affects a whole lot of people, not just the losing bidder and the procuring entity. There are implications also for someone who actually wins the contract. Because most people always think that we've won the contract, so we're safe. What if you have entered into negotiations on the basis that when you win that contract, that will be the source of funding for that negotiation? You need to protect yourself, and you need to actually have legal ways of addressing those kind of risks that may arise. Damages was always awarded, but now, obviously, it's becoming a bigger issue, and it could even be more than what was the case in the past. In addition, there's what is called shortening of contracts, where this occurs where, for example, a declaration of ineffectiveness is made, and maybe the court feels that there is need to, rather than cancel the whole contract, to actually limit it for a certain number of periods. And of course, we've got the declaration of ineffectiveness and financial penalties. One other point I want to mention here that may affect winning suppliers is the fact that may affect procuring authorities is the fact that you need to, in your contracts with incumbent suppliers, you need to actually make sure you put in like transition provisions, so that if you have a set aside and you need to go out to reprocure again, you're not left out in the lodge. There's nothing for you to actually carry out that activity. So if you've got like a fallback mechanism, for example, with your incumbent supplier to continue providing that service, then that may help you. That point cannot be overemphasized. It happened to me when we were in the department. I was in the one department before, and that was when the new remedies legislation came in. We had a contract for the supply of training for dyslexia services, which the government national target required us to fulfill. Unfortunately, it was a Part B services contract, so nobody really paid serious attention to it, and nobody thought anybody would challenge. But we found out that 32 providers all came, because in the past they had been used to getting these contracts as a matter of course. And this particular year, we actually decided that the department took a decision that because of the fact that we want to start making our procurement practices more transparent, let's go out to tender. So in the process of going out to tender, a lot of people failed to win the contract. And we found ourselves in a situation where we had 9 new providers, but we couldn't go out with them because these 32 people, the challenge, had prevented us from doing so. And we had no proper exit clause or transition clause for the incumbent suppliers to continue providing those services until we were able to move on to the next step. So it's important to bear that in mind. As a procuring entity, make sure you have transition process in case something does happen. And in this general climate, something always seems to be going wrong. Okay, here, basically, I'm just trying to present to you the merging picture where what we're seeing in the UK. Like we've noticed, I mean, Pedro and Dermot have already mentioned, culturally, there was no tradition of bid protest. Generally, suppliers, you don't win the contract, you take it on, and then you go out and you compete for the next opportunity. But slight increase in procurement litigation over the last few years. We're seeing about 20 cases per year. Dermot will talk more about this in the afternoon. Interestingly, most cases are coming from Northern Ireland. And I was listening to a speech made by one of the judges that has been involved in most of them. And it says it could either be because they have a more litigation-conscious culture, or because of the fact that there's nothing in Northern Ireland to reap from apart from the public sector. So it might be that the fact that their only source of income is the public sector. So because of that, they're going to court to ensure that they win more opportunities. And we've kind of like identified the areas, and this would be of importance to both suppliers and procurers. One of the main areas that challenges are coming from award criteria. So as a procuring entity, you need to make sure that you get this very well. The weighting as well. We know the principles that have been enunciated in cases. You have to use only the weightings that you have disclosed to suppliers. What happens is that in my previous life, we would go out into a tender process, and when we're doing evaluation, we suddenly realize we did not state the weightings. Then it might have been overlooked, but now there is more scrutiny. Somebody mentioned freedom of information. I bet you when these things go to court, what happens is that even that paper, you know, the spreadsheet you use for calculating the marks, all that could be asked for. So you need to have a very good trail of record and documentation keeping process that will protect you as a procuring entity.
Just because of time, I'm covering all of these areas by case law.
Okay.
I think it's very, I mean, just look there, award criteria, weighting, evaluation methodology, lack of transparency. There are cases now in all of these areas, and we'll give you practical examples later on.
Okay, and then this is just a picture, and I won't bother you about that. We've kind of touched about this understanding issue, so I won't bother you about it, but basically to bear in mind that understanding, the basic thing to remember is that any person who alleges or that he or she has suffered or risks suffering loss may challenge, while in judicial review, anybody with sufficient interest in the matter. So this will determine which kind of actions to pursue. This is another vital point to remember, time limits. There's almost a race against time now, and although the EU law permits member states to impose reasonable time limits for initiation of proceedings, UK law initially implemented was held to be non-compliant in the Uniplex case. So from 1st of October last year, a new law took effect, the amendment regulations, and it is 30 days from date of knowledge for the general cases. The ineffectiveness claims are still this 3 months duration. But always remember that the court has discretion to extend. Again, it is whether you can justify that to the court. And standstill, we won't bother too much about that because most people would be very conversant with this issue. Essentially, note the differences between the old and the new regime. in the old regime, you used to have a two-stage process. Debriefing was only given if it was requested. Here, everything needs to be set out at the outset. So very important to bear that in mind, especially for suppliers as well. If you get a letter and it's above threshold contract, or is a procedure that adopts above threshold principles, and then you don't have all the information set out, that could be a potential ground. So look at all documentations you receive from suppliers in careful detail. We've looked at the remedies. What I've just done with these slides is to distinguish them, so I won't bother you about them again. And the main thing that I want to look at shortly is this, what's happening with automatic suspension. Now, what happened was that with the previous regime of getting an injunction was regarded as being very laborious for litigants. So when the new rules were brought in, it was perceived that it would make things much easier for litigants. Unfortunately, a number of cases that have come out in the last, in 2010 and 2011, have shown that this is not always the case. Because the courts are still applying the principles that they use in granting injunction. Basically, that's what's stated in, before the courts can maintain the suspension, what they need to decide is that, is there a serious issue to be tried? Would damages be an inadequate remedy? And does the balance of convenience favor holding up the procurement exercise? Unfortunately, it's a very, very tough test that suppliers are having difficulties with actually satisfying. And what we've seen is that in a number of cases, the courts are lifting up the automatic suspension rulings rather than maintaining them. So it's something to watch out before you go to court. Would it be such that the courts would rule in your favor or not? And these are the cases I've just highlighted here. The slides would be available to you electronically. The future, I put possibly because nobody can actually say with certainty, but it does look like there will be more legal challenges. One thing that's happening, and I've been speaking to some barristers on this, is that a lot of litigations would have been going on in court, but a lot of settlement actions are taking place. So the fact that we're not seeing litigation as much as predicted does not mean that they might not have occurred. What the barristers are saying is that settlement actions are ongoing. And so probably as a procuring entity or as a supplier, these are issues to be looked into. Is it something that you will be willing to settle, or is it something that you are more willing to pursue? And there are consequences. Emma will talk more on this, on a range of stakeholders, from contracting authorities, successful bidders, which we've highlighted in the course of the presentation. I've just indicated some few tips for suppliers. It's important to know the obligations that are owed to you by contracting authorities. I think one of the biggest mistakes we make as suppliers is to assume an obligation is due to us. Most suppliers always think of, why can't contracts be awarded to me? I'm a Welsh business. Why can't the contract be awarded to me? That's not an obligation that's owed to you. So know the right obligation that owed to you. Also, on receipt of the notification letter, make sure you undertake all these steps that I've indicated. Check for whether it complies with the requirements of EU law, if it's above the EU threshold, and if the contract was awarded using one of the EU procedures. Importantly, if you are the successful bidder, check that the contract was advertised correctly, and secondly, that the standstill period was obeyed, because this could mean that though you have won the contract, there's no victory for you. And again, I cannot overemphasize the importance of training. You can only achieve all this with the right training, and we are always here to provide that training. For contracting authorities, importantly, know your status. What that means is that, one of the things that Demos will be sharing with us would be that, are you actually a contracting authority? Is that contract actually covered by EU procurement rules? Or have you inadvertently applied a rule that should not have been applied in the first place? So it's important to actually check that. Follow the public procurement rules diligently. Cannot be overemphasized. Sometimes it's better to err on the side of doing too much than too little. One thing that emerged is that the quality of debrief information, a lot of complaints that we're getting is that since the new remedies regime, procuring entities feel that once they've given you the notification letter, there's no other further obligation to have some feedback sessions with you. Yes, they may be correct in the sense that there are no statutory obligations, but sometimes talking and taking the supplier through what went wrong may actually forestall legal actions. So it might be important for you to just have a word with them. And in certain instances, you need to publish, especially with Part B services or services that you have not awarded through the full OJU process. You need to publish voluntary ex-ante transparency notice. Again, I've indicated training cannot be overemphasized. And in recent days or months, what we are seeing is that there's a lot of procurement fraud that is coming out. So watch out for that. Get your risk assessment units involved to actually make sure that the procurement officers are doing what they are trained to do. And I've indicated that face-to-face meetings are very, very essential. Thank you.
That's great. I think